Sir, good evening, sir.
Good evening to the participants of the All India Bar Examination 17th Court 2023. You are welcome. Karibu sana in Kiswahili. Anyone can unmute and read what I posted on the screen.
Multiple choice question in public virtual class from 9:10 p.m. to 10 p.m. Public interest litigation. Virtual class on Monday, 23rd, 1st, 2022. Professor Dr. Mohammed Saheb Hussain.
Is it 22? 2023.
23, sir. 23,
Yes.
sir.
So now, without wasting the time, that we will come to our All India Bar Examination 17th Court 2023. Be ready for the first question. Who is called the father of PIL? I don't want to show the options. You have to tell me. Of course, the options are here.
P.N. Bhagawati. Justice Bhagawati, sir.
It is Justice Bhagawati is the right answer for the question, who is the father of the PIL? Yes, Justice Bhagawati has been called the father of public interest litigation in India due to his contribution to public interest litigation jurisprudence. Justice Bhagawati was the Chief Justice of India from July 12, 1985 to December 20, 1986. Now, second question. The first reported case of the PIL was dash in 1979. Few important facts of the case are as follows. This case focused on the inhuman condition of the prisons and under trial prisoners. Option A, M.H. Hoskot versus State of Maharashtra. B, Hussain-AIBE-XVII versus State of Bihar. C, Banwari Devi case. D, Nirbhaya gang rape case.
B is right answer, sir. Hussain-AIBE-XVII versus State of Bihar.
The B is the right answer. It is a Hussain-AIBE-XVII versus State of Bihar is the right answer for the second question. Third question. In which case was PIL defined? A, Veeraswamy versus Union of India and others. B, Supreme Court versus Union of India. C, S.P. Gupta versus Union of India. D, All India Anna Dravida Munnedra versus the Union of India.
C is right answer, sir. S.P. Gupta versus Union of India.
It is C is the right answer. S.P. Gupta versus Union of India. I repeated these 3 or 4 questions simultaneously. It was in the case of the S.P. Gupta versus Union of India that the Supreme Court of India defined the term public interest litigation in the Indian context. Who among the following is connected with the PIL? Justice Gajendra Gatkar, Yashwanta Vishnu Chandrachud, Justice Hidayatullah, P.N. Bhagawati. Just before you give the answer. Who?
Justice P.N. Bhagawati.
P.N. Bhagawati, Justice. What is the P.N. full form? Supplementary question.
Prafulla Chandra Natwarlal Bhagawati. Sir, Prafulla Chandra Natwarlal Bhagawati.
Yes, is the Prafulla Chandra Natwarlal Bhagawati was the Chief Justice in India 1986 when he introduced the public interest litigation in India. Yes, which is not the PIL case law among the 4. See, the 4 case law I have given, which is not connected with the PIL case law. A, Vishaka versus State of Rajasthan. B, Javed versus State of Haryana. C, Chandravansh Mani Singh versus CPIO Railway SW Railways. And D, Parmanand Katara versus Union of India.
Javed versus State of Haryana, sir.
Wrong.
Option C, Chandravanshi Mani versus CPY versus Railways.
It is not connected with the Chandravanshi Mani Singh versus CPIO, the Railway SW Railway. That is not connected with the PIL. Yes, one railway company, railway board is there, and where it is also PIL case. What is the name of the case? And she is a Bangladeshi woman. She was gang raped by the railway employee, the railway Nivas in the Calcutta.
Vishaka versus state of
No,
Rajasthan,
the
sir.
Vishaka versus state of Rajasthan is Rajasthan, and she was there because she was against the child labor, child marriages, and she was gang raped by the Rajasthan people. I think that is the
Right answer.
Chandramani Devi, Chandramani Devi versus Railway Board, and it is also PL case law. So that is the way I get Chandra I written so that we could know it. Okay, what was the old name for the PIL? PIL Italica Lifestyle Limited, or Peacock Lifestyle Limited, B. Panama Industry Limited, C. Peahen Industry Limited, D. Pigeon Industry Limited. The old name of the PIL.
B is right answer, sir. Panama Industry Limited.
Wrong. WRONG.
Option A.
That is a PIL Italica Lifestyle Limited or Peacock. But you have to choose from the options given. You are not assumption and not presumption. Peacock Industry Limited. The company has changed its name from Peacock Industry Limited to the PIL Italica Lifestyle Limited. So the old name for the PIL is PIL Italica Lifestyle Limited. Suppose if it is given Peacock Industry Limited and PIL Italica Lifestyle Limited, then you have to say PIL Italica Lifestyle Limited. Suppose the PIL Italica Lifestyle Limited is not given over there, Peacock Industry Limited given there, then you have to choose for the Peacock Industry Limited. Is it clear?
Yes, sir.
Yes, sir.
Seventh question. Anyone can unmute and read seventh question.
The concept of the public interest litigation,
Concept
PIL.
of public interest litigation.
See, one has started, the other man should have to drop.
The concept of the public interest litigation within parenthesis PIL originated and development in the USA in the A option 1950s, B option 1955s, C option 1960s, D option 1967, 65s. D is right answer.
If it D, Delhi is the right answer. WRONG.
Option C, 1960s.
Option C, 1960s is the right answer. Because I twisted the question. I know that where the originator means everybody say USA. Okay, eighth question. Who can file a PIL? A PIL, that is a public interest litigation, is a petition that can be filed by any member of the public for any matter of the private interest for a redress of public wrong or injury. B. A public interest litigation is a petition that can be filed by an injured person for any matter of the public interest for redress of public wrong or injury. C. Public interest litigation PIL is a petition that can be filed by any member of the public for any matter of the public interest for a redress of the public wrong or injury. D. A public interest litigation PIL is a petition that can be filed by any member of the public or any matter of public interest for a redress of private wrong or injury. Now you can
C
shoot.
is right answer, sir.
Yes.
C is right answer, sir.
CAT cat.
Yes, sir.
D is a Delhi.
C, sir.
Say CAT cat. Okay, C is the right answer
Yes,
for
sir.
this question. A public interest litigation PL is a petition that can be filed by any member of the public for any matter of the public interest for a redress of the public wrong or injury. What is the wrong in A?
Private.
Private interest.
Private interest, sir.
Yes. What is wrong in B?
No.
What is wrong in B? By an injured
Filed by
person.
By any
It is
injured
not by injured person. It is by a member of the public, not injured person.
Yes.
Yes, sir.
What is wrong in the D?
Private.
Private.
Yes. So now ninth question. The Supreme Court devised the mechanism of public interest litigation in dash. A. 1960, B. 1965, C. 1975, D. 1980.
Option B, 1965.
WRONG.
1960, sir.
WRONG. See the question.
1975.
The Supreme Court devised the mechanism of public interest litigation. A mechanism is devised. The beginning is 1960.
1975, sir.
WRONG.
D is right answer.
D, that is the 1980 is the right answer for the ninth question. Is it clear?
Yes, sir. Yes.
Yes, sir.
10th question. Anyone can unmute and read. Those who read, give the chance to other people. Quick.
Who is the mother of the public interest litigation? Option A, Pushpalata Hingorani. Option B, Kapila Pushpa Hingorani. Option C, Pushpa Nirmala Hingorani. Option D, Pushpa Kapila Hingorani.
D is right answer, sir. Pushpa Kapila Igorani.
This is also a repeated question. Feedback. Pushpa Kapila Hingorani was an Indian lawyer who regarded as a mother of public interest litigation, PIL. As per then prevailing laws, a petition could be filed only by a victim or a relative. Kapila and her husband, Nirmal Hingorani, wanted to represent the under trial prisoners in Bihar. So 11th question. Which statement is the right statement? A. Public interest litigation is the use of the law to advance the human rights and equality or raise issue of the broad public concern. It helps to advance the cause of minority or disadvantaged group or individuals. B. Public interest litigation is the use of the law to advance the human rights and equality or increase the issue of the broad public concern. It helps to advance the cause of minority or disadvantaged group or individuals. C. Public interest litigation is the use of the law to advance the human rights and equality to raise the issue of broad public concern. It aids to advance the cause of minority or disadvantaged groups or individuals. D. Public interest litigation is the usage of the law to advance the human rights and equality or raise issue of the broad public concern. It helps advance the cause of minority or disadvantaged groups or individuals. So A, B, C, D is the options which I have given here, and the statement is the right statement, either A or B or C
Option D.
or D.
D.
D is the right answer. WRONG.
B is right answer, sir. B is right answer.
WRONG, wrong.
Option C.
WRONG.
Option A is right answer, sir.
Option A is the right answer. What is the wrong in D? Can you tell me? What is the wrong in that? I say usage. Litigation is the usage of the law. It is not the usage of the law. It is the use of the law. Okay, what is wrong in the B? What is wrong in the B?
Increase.
To arise, I say increase. Okay, what is wrong in the C? It helps
Aids.
actually, but it aids. I wrote aids to advance the cause of minority or a disadvantaged group of individual. Actually, it helps. Is it clear now?
Yes, sir.
Sir.
Right answer is
Option A.
option A. Okay. Anyone can unmute and read? Give the chance to the other person who did not speak.
Who is PIL Man of India? PIL Man of India. Option A, Mahesh Chandra Mehta. Option B, Ponnuswamy. Option C, Upadhyaya. Option D, Chandra Mani.
A is right answer, sir. Mahesh Chandra Mehta.
WRONG.
Chandramani, sir.
WRONG.
Ponnuswamy.
Upadhyaya, sir.
Among the Ponnuswamy and Upadhyaya, you have to select it now. Upadhyaya is the right answer. With over 150 pills, within parentheses 125 in the Supreme Court and 25 in the Delhi High Court, to his name, Upadhyaya is referred as the pill man of India, the judicial tool being the weapon of choice to battle the sundry problems dogging the nation. So I know that definitely you people definitely make the Mahesh Chandra Mehta because MC Mehta filed. MC Mehta is a green revolution man. Okay, 13th question. What cannot be treated as a pill? Number 1, no petition involving the individual matter shall be entertained as a pill matter except the indicated hereinafter. 2, no petition involving the personal matter shall be entertained as a pill matter except the indicated hereafter. 3, no petition involving the family matter shall be entertained as a pill matter except the indicated hereinafter. 4, petition is involving the public matter shall be entertained in the PIL matter except as indicated hereunder. So out of the 1, 2, 3, 4, here I have given the option. Option A, 1 plus 2. Option B, 1 plus 2 plus 4. Option C, 1 plus 2 plus 3. Option D, 1 plus 2 plus 3 plus 4.
Option B, 1 plus 2 plus 4.
Actually, okay,
Sir,
tell
1 plus 2
me.
plus 3.
Okay,
1 plus 2 plus 3.
yes.
1 plus 2 plus 3.
See, I say what cannot be treated as a PL? Please note the point. Cannot be
Family,
treated.
sir. Family is wrong, sir.
So
Family
1
is
plus 2
wrong.
plus 3 is the right answer. Means cannot be treated. Because fourth one is the correct one. Petition involving the public matter shall be entertained as the PL under the except as indicated hereinafter. But I asked the wrong way. What cannot be treated as a PIL? Means fourth one can be treated as a PIL. But why the first one cannot be treated as a PIL? The reason is no petition involving the individual matter. There is no individual matters. Number 2,
Yes, sir.
involving the personal matter, no personal matters. Number 3, no, involving the family matter, no family matters. Is it clear?
Yes, sir.
Yes, sir.
And hence, here the question answer for this one is 1 plus 2 plus 3 is the right answer. But actually a PIL can be filed for the fourth one. Is it clear?
Yes, sir.
Yes, sir.
Yes. Now 14th question. Justice Krishna Iyer first introduced the idea of public interest litigation in India in 1976. A. Association of Residents of the Moho versus Union of India. B. Measures P. R. Securities Limited versus New versus DCIT. C. Mumbai Kamagar Sabha versus Abdul Bhai. D. The Commissioner of Income Tax versus Raza Textile Limited. This is a repeated question.
He is right
C is
answer,
right
sir.
answer, sir.
Commissioner of Income Tax
Kamagar
versus
Sabha.
Raja Textile Limited.
Abdullabai. C is right answer, sir.
See, both of them have said at that time. If you say the D, it's the wrong answer. If you say the C, it's the right answer. I said it's a repeated question.
Yes, sir.
Because I know which I repeated, which I not repeated. Okay, 15th question. Areas of public interest law include all 3 except 1. Find out the odd man among 4. A. Civil rights and liberties. B. Women's right. C. Children's and youth service. D. Migrant issues.
Migrant issues, sir. D is right.
Then what should be the right answer? Instead of right
Sir,
migrant
D,
issue,
odd
what
man
should
out.
be there?
Civil rights and liberties.
Immigrant issue should be there. I removed the immigrants, I wrote the migrant issues. Now,
Yes, sir.
16th question. PIL should not suffer from inordinate delay and virgule or latches. I repeat, PL should not suffer from inordinate delay and or latches, which is observed in the case of A. Gurpal Singh versus State of Punjab, B. Kripal Singh versus State of MP, C. R&M Trust versus Koramangala Resident Vigilance Group, D. Santosh Singh Yadav versus State of UP.
B is right answer,
B is
sir.
the right answer, sir.
Kripal Singh versus State of Madhya Pradesh.
WRONG. If you say the B, shoot the second
C
option.
is the right answer, sir. C is the right answer.
C is the right answer. R&M Trust versus Koramangala Resident Vigilance Group is the right answer for the 16th question. Now, 17th question. Areas of public interest law included all three except one. Find out the odd man among four. A. Worker rights employment law. B. Consumer rights. D. C. Public aid. D. Gay and lesbian rights.
Sir, option B, consumer rights.
WRONG.
D is right answer, sir. Gay and lesbian rights.
There is a gay and lesbian rights are there. Transgender. There is
Public aid, sir.
National Legal Service Authority versus Union of India. It's a easy question, but I don't know why you are not making.
Sir,
See,
option A,
there
workers'
is a
rights.
public
employment.
benefits are there, not public aid is there.
Yes, sir.
There is a public benefits are there, public aid is not there. 18th question. In areas of public interest law, which option is the correct option? Area of public interest law, which option is the correct option? A. Environmental law. C. Prisoner's right. 3. Euthanasia. 4. Capital punishment. Here I have given the options. A. 1 plus 2. B. 1 plus 2 plus 3. C. 1 plus 3 plus 4. D. 1 plus 2 plus 4.
B is right answer, sir. 1
Euthanasia
plus 2
meaning?
plus 2.
Yes?
B is
Sir,
right answer. 1 plus
If you
2
say
plus
D, WRONG.
Sir,
One plus
euthanasia
sir.
B
meaning?
is right.
2. B, sir.
1 plus 3 plus 4, right, sir?
WRONG. No.
B.
It is the C is the right answer. 1 plus 3 plus 4 is the right answer.
Sir, euthanasia meaning, sir?
Self-incrimination, dying, requesting somebody is to give the toxic injection so that he could die without suffering.
Yes, sir.
Yes, but no, it is not the right answer, but I will give that. See, I twisted it. Death penalty is there, but I wrote the capital punishment. Even euthanasia is not there. Because I know it, euthanasia is not there in the, to my knowledge, area of public interest.
Sir, option A, 1 plus 2.
Option A is the right answer. Because I added euthanasia because I checked everything. Then I added the capital punishment. So capital punishment, we should not say death penalty, we have to say. So the right answer is 1 plus 2. Is it clear?
Yes, sir.
Yes, sir.
19th question. In euthanasia, okay, let us come to the point now. 19th question. It is through the mechanism of public interest litigation that the court seeks to protect the human rights by expanding the meaning of dash so on emerge as a human right. A. Fundamental rights to equality. 2. Life. 3. Personal liberty. 4. Only 1 plus 3. So now, option I have given. A. 1 plus 2. B. 1 plus 3. C. 1 plus 4. D. 2 plus 4. See, check it here. A. Fundamental rights to equality. 2. Life. 3. Personal liberty. 4. Only 1 plus 3. Here I have given
1 plus 3.
and you choose the which is the right option.
Only 1 plus 3.
WRONG. See, logic here. I wrote
Sir,
number
sir.
1, fundamental rights to equality. Number 2, life. 3, personal liberty. But 4, only 1 plus 3 I wrote. So now
Sir.
you choose from here. There is a critique is there. A little litigation is there. And if you know it, and you can shoot it.
1 plus 3.
See, actually, fundamental rights to equality, it is there. PIL. Life, it is there. Personal liberty, it is there.
2 plus 4. Option
2
D. 2
plus
plus 4.
4 is the right answer. 2 plus 4 is the right answer. Everything is there. A technicality I used here. So 2 plus 4 is the right answer. Is it clear?
Yes,
Yes,
sir.
sir.
Because it covers everything. Okay, second question, 20th question. It is through the mechanism of the public interest litigation, PIL, that the court seeks to protect human rights by expanding the meaning of the fundamental rights to equality, life and personal liberty. In this process, dash, so on emerge as a human rights. Number 1, the right to speedy trial. 2, the free legal aid. 3, dignity. 4, means of livelihood. And options: A, 1 plus 2, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4. See the options.
Sir, option D. 1 plus 2
WRONG.
Plus 3 plus 4 is right, sir.
What is that?
B is right answer.
2 plus 3 plus
B,
4.
BOX box B,
Yes, sir. B.
WRONG.
Option A. 1 plus 2.
WRONG.
C is right answer, sir. 1
What
plus
is
3
that?
plus 4.
CAT cat.
Yes, sir. 1 plus 3 plus 4.
Why is 1 plus 3 plus 4 is the right answer? Tell me, reason. If you see the free legal aid, do you know what is the spelling of aid?
AD.
AID only. But what I wrote?
ADE.
Sir, thought that by mistake E is there.
No mistake,
reading-
voluntarily. No mistake, no assumption, no presumptions. No assumptions, no presumptions.
Okay, sir.
Yes, 21st question. It is through the mechanism of the public interest litigation that the court seeks to protect the human rights by expanding the meaning of the fundamental rights to the equality, life, and personal liberty. In this process, dash, so on emerge as a human rights, find the odd man out. Number A, schooling. B, housing. C, medical care. D, clean environment. Which one is the right answer?
Clean environmental, sir.
I say, which is odd man out.
Option A. Schooling.
If I say, okay,
Sir,
you are right in schooling, but what is actually the wordings there? Okay, I do admit you are right. You know, but I want the logic. It is education. It is education is there, not schooling. Is it clear?
Yes,
Yes,
sir.
Yes, sir.
Good. 22nd question. So same, it is through the mechanism of the public interest litigation that the court seeks to protect the human rights by expanding the meaning of the fundamental rights to equality, life, and personal liberty. In this process, dash on the emerging human rights as human rights, which one is odd man out? A, right against the torture. B, domestic harassment. C, sexual harassment. D, solitary confinement.
Option D. Solitary confinement.
WRONG.
A is right answer, sir.
A is right answer.
Right
WRONG.
against torture.
A is right answer, sir.
The right answer is here not connected is domestic harassment. It's
Yes,
odd
sir.
man out. Not connected with it. Sexual harassment, but not domestic harassment. 23, third question. Public interest litigation has its evolution from the USA. I repeat the question. Public interest litigation had its evolution from the USA in the famous case of Dash. A. Dred Scott versus Sanford. B. Brown versus Board of Education. C. Gideon versus Wainwright. D. Mirinda versus Arizona.
A is right answer, sir.
WRONG.
Mirinda versus Arizona.
WRONG.
Sir, option B, Brown versus Board of Education.
WRONG.
C is right answer, sir.
Gideon versus Wainwright is the right answer. Supplementary question. In which year PL is found in the USA?
1960.
1960.
1960 is India. No, because case law I am speaking. Case law. This case law is 1963 case law. Gideon versus, it is the first case law in the PIL. Even though it is 1960, earlier it has come out, but the first case law is a Gideon versus Wainwright is the first case law. And India, what is the first case law?
Hussain-AIBE Khatun, sir.
Yes,
Versus
which year?
India.
Year.
1963, sir.
1967, sir.
So, which case law first come into the existence in the world?
Bombay.
Gideon versus Wainwright case law in the USA 1963. Now, another important question is there. In this question, lawyers in criminal courts are necessities, not dash. A. Extravagances. B. Extras. C. Fancies. D. Luxuries. I repeat.
Fancies, sir.
Lawyers in criminal court are necessities, not dash. Extravagances. B. Extras. C. Fancies. D. Luxuries.
D. Luxurious.
It is the luxuries is the right word. They say the reason is Gideon versus Wainwright 1963 issue. Does the Constitution requires an individual charged with a felony but unable to pay for a lawyer be guaranteed the free assistance of the legal counsel? The result is, answer is yes. According to the unanimous Supreme Court, the court held that the Sixth Amendment right to assistance of the counsel applies to the criminal state trials and that lawyers in criminal courts are necessities, not luxuries. Is it clear?
Yes, sir.
25th question.
Yes, sir.
A writ petitioner who comes to the court for the relief in public interest must come out not only with the clean hands like any other writ petitioner, but also with a clean heart, a clean mind, and clean objective. In which case law it is made? A. Ramjas Foundation versus Union of India. B. K.R. Srinivas versus R.M. Premchand. C. The Environment and Consumer versus Union of India. D. Prashant Mehta versus State of HP.
Option C. Environment and Consumer versus Union of India.
WRONG.
D is right answer, sir. Prashant Mehta versus State of.
D is the right answer. Is the Prashant Mehta versus State of SP. A person who comes to the public interest litigation should come not only with the clean hands like any other writ petitioner, but also with a clean heart, clean mind, and clean objective. So 26th question. Which statement is wrong among the four? A. Every PL must indicate that the petitioner has no personal interest in the case. B. If he has any personal interest, he must disclose the same. C. In the event of the High Court finding the claim as a frivolous or vexatious, the PL shall be dismissed with the variable cost. D. No public interest litigation petition will be entertained in the respect of the civil disputes between the individuals or in service matters. Wrong among the four.
D is right.
C
D
is
is
right
wrong.
answer, sir.
Why?
D is wrong, sir.
C C is the
Why
right
C
answer.
is
sir.
wrong? Tell me.
Individuals na
Sir,
sir.
D is wrong, sir.
Only one is wrong here. Yes, you have shooted correctly. That is the C is the wrong answer. Okay. I say why? See, in the event of the High
Frivolous.
Court finding the claim as frivolous and vexatious, the PL shall be dismissed with the variable cost. You
Yes, sir.
shooted right, but I want the reason. Say pass on. You cannot give the reason. I know it.
Pass on.
It's a tough one. Variable cost, no, exemplary cost. I wrote the variable cost is exactly exemplary cost it is. Okay. 27th. In the matter of dash, it was observed that what? Oh, I forgot the case law. No, it is observed that, yes, if the quotation is here. It cannot be said that the rules of the procedure law don't apply in the PL. The caution is always added that every technicality in the procedure law is not available as a defense in such a proceedings when the matter of the grave public importance is for consideration before the court. This was observed in which case law? A. Narmada Bachao Andolan versus State of Madhya Pradesh and others. B. That is Nersvin Boro and others versus the state of Assam and 4 others. C. Rupan Sahu and another versus Ananda Kumar Sharma and others. D. Rajasthan state versus Subhash Sindhi Corporation Hooghly Society. HSC Society.
Narmada
Yes.
Bachao.
It is said Narmada Bachao Andolan versus state of Madhya Pradesh and others. The PAL, the statement which I read is observed over there. So the A is the right answer for the 27th question. Now 28th question. Furthermore, the doctrine locus standi was relaxed in the case of. Doctrine of local standi should be there actually to file a case. But in the PAL, it is relaxed. In which case law? A. Ramjas Foundation versus Union of India. B. K.R. Srinivas versus Rama Premchand. C. The Environment and Consumer versus Union of India. D. Mumbai Kamgar Sabha versus Abdul Bhai.
Sir, option B,
C
KR
is right
Srinivas
answer, sir.
versus
Environment.
If you say BAG bag K.R. Srinivas versus R.M. Premchand, WRONG.
C is right answer, sir.
The Environment and Consumer versus Union of India is the right answer. WRONG.
D is right answer, sir. Mumbai
D.
Kamgar Sabha versus
Mumbai Kamgar
Abdullah Bhai.
Sabha versus Abdul Bhai. When you are giving the answer, you have to read the full. I don't know whether it's saying D or B or C. Either you can say CAT cat or DOG dog or Delhi, D Delhi. Or you have to say D answer, Mumbai Kamgar Sabha versus Abdul Bhai. If the local standard is not there, even still we can file a case because it is the public matter. Is it clear?
Yes, sir.
Yes, sir.
Okay. 29th question. The court, through public interest litigation, have introduced a new dimension to our dash. Private international law, B. Private law, C. Administrative law, D. Public law.
Public law, sir.
It is a public law.
D is right answer.
The D is the right
Yes, sir.
answer. The last one is that. And 30th question. Unsubstantiated pleas should not be made in the PL decided in the case of dash. Unsubstantial pleas means frivolous reasons should not be come to the PAL. A. Manohar Lal Sharma versus the Principal Secretary and others. B. State of West Bengal and others versus Darbar Mahila Samanvaya. C. Subramania Swamy and others versus Delhi Police and others. D. Energy Watchdog versus Union of India and others. A frivolous, unsubstantiated, untruthful should not bring into the PL, in which case it is decided.
Sir, option C, Subramania Swamy and others versus Delhi Police.
You are right, it is the option C, that is the C for the cat. Subramania Swamy and others versus Delhi Police and others. They say unsubstantiated or frivolous cases should not be brought to the court. the Supreme Court. Even the Supreme Court penalizes some 1,000, 2,000 or 10,000 also in one of the case law to the advocate who filed the case because he has wasted the time of the Supreme Court. 31st question. The judiciary has played a dash role in the expansion of the public interest litigation by relaxing the rule of local standi. At the same time, had cautioned against the abuse of such relaxation. A. Classical. B. Pivotal. C. Exemplary. D. Tremendous.
C. Exemplary.
B is right
I
answer.
already made
Tremendous.
the question one there. I have forgotten it. Okay, but doesn't matter. I want to see whether the memory is sharp or not. So answer
Exemplary
is
and
Tremendous, sir.
no. Exemplary is the right word. The exemplary is the right word. C. So 31st question.
Yes, sir.
32nd question. In service matters, PL should not be entertained. I repeat. In service matters, PL should not be entertained was decided in the case of A. Dakshinamurthy versus the Commissioner of the Tiruvallur Municipality. B. Manohar Lal Sharma versus the Principal Secretary and others. C. State of West Bengal and others versus Darbar Mahila Samanvaya. And D. Dr. Duryodhana Sahu and others versus Jitendra Kumar Mishra and others.
C is right answer, sir. State of West Bengal and others versus Darbar Mahila Samanvaya.
WRONG.
Sir, option B, Manohar Lal Sharma versus the Principal Secretary.
WRONG.
D.
D is
Dr.
right answer, sir.
Duryodhana Sahu and others versus Jitendra Kumar Mishra and others.
The D is the right answer. Dr. Duryodhan Sahu and others versus Jitendra Kumar Mishra and others. It is the right answer. So 33rd question. 33. In Lily Thomas versus Union of India 2000 case, a PL was filed regarding the dash of the Representation of the People Act 1951, contending that the said section was in contravention with Article 14 of the Constitution. A. Section 8.1. B. Section 8.2. C. Section 8.3. D. Section 8.4.
Option D, Section 8 of 4.
Repeat.
C. Section 8 of the
Option
3.
D, Section 8.4.
Class 3.
Option D is the right answer. That is Section 8.4 is the right answer. Because I twisted the question. If I say anything, we know, sir, it is about a person who is contesting for the election should not have the criminal record. Okay, 34th question. The question was whether the third party who is a total stranger to the accused has any locus standi to challenge some convictions and sentence. The court held that the petitioner had no locus standi to file a petition, being the total stranger to the prosecution, and more than that, they were not even the authorized by the convicts was decided in the case of dash. A. Simranjit Singh versus Manas versus Union of India. B. Simranjit Singh Man versus Union of India. C. Vinod Kumar versus State of UP. D. Dattaraj Nathuji Taware versus State of Maharashtra. Jai Hind.